Um, Hello everyone. Good evening. Okay. Good morning. Okay. Good morning, sir. Thank you so much for that thumbs up. Good morning, everyone.
Good morning.
Thank you so much all for joining into the session. I can see we already have Mr. Gabriel on call. Please, I would like to encourage all mentees to join in on the session. And if you have friends that are yet to join in on the call, please, you can kindly notify them that we have started class already. You can share with the members of your group, letting them know that the session has officially started. So moving on, good morning or good afternoon, rather, once again. My name is Dennis Williams, and I'll be your moderator for this class. You're welcome to week 5 of the third and fourth quarter of 2024 for the Artificial Intelligence and Technology class. We've gone through week 1, and now we are in week 5, and I'm sure it has been an interesting learning experience so far. And slowly we are getting to the end of the mentorship program in itself. So I want us to, as much as possible, try to take as much advantage of what we have left of the program, try to make sure that we are always available for class, doing what we are supposed to do. And I'm sure you will get the best out of this mentorship program. So moving on, last week we started announcing that GIIPCC is giving the opportunity for people to register for a free legal clinic. The clinic is for creatives, entertainers, athletes, innovators, and startups. And what those professionals are going to get is a 20 minutes consultation with our professionals who are legal experts in their own various field of law. They would be giving advice and consultations to those who are in need of those services. Also, right, they will be looking at your contracts if you have one, and they will be doing a review on that. So you can kindly take advantage of this opportunity. You can share the flyer with your friends, colleague, family members who might be interested in this opportunity. If for further information, please kindly reach out to me, and I will do all to guide you directly and share all the necessary informations that you will need. Moving on, I would like to introduce our mentors for today's class, the mentors that we're expecting in the session for today. We've already sent out the flyers to the mentees, but just for posterity's sake, I'll just kindly be introducing them quickly. Firstly, we'll be having Mr. Ridwan Badmos. Mr. Ridwan Badmos is not yet here on the call, but we hope and we're expectant that he'll be joining us shortly. Okay, Mr. Gabriel Udo is already with us, and I'm sure he would be helping us run through and giving us a perspective on the course or the subject matter we have for today. Thank you so much, Mr. Gabriel, for joining us. Mr. Gabriel has been with us. He was with us in the last class, and he was also with us, I think, in week 1. So Mr. Gabriel is no stranger to us. We know that he's full of content and he's full of quality, and he will be delivering in this particular class. Thirdly, another mentor that we've had in the previous class is Magdalena Cogni. Magdalena would be with us hopefully in this session, and we'll also be getting to hear from her rich insights into the subject matter for today. Fourthly, we'll be having a new mentor, and I will just quickly be reading through his profile, saying that this is the first time we'll be having him in class. Our expected mentor for today is Professor Samuel Samai Andrews at Al Yamaha University. His role encompasses educating the next generation in the practice and profession of law, including intellectual property law, with a focus on its intersection with Sharia, as well as engaging in research and curriculum development. His responsibilities reflect a continued commitment to emerging innovative legal education with traditional principles as an off counsel as the Law Temple Associate. He provides expert legal advisory service, leveraging deep knowledge in IP rights management and commercial law. The organization benefits from his multidisciplinary approach to law, particularly as he navigates or as we navigate the complexity of intellectual property rights and artificial intelligence systems evolution in ownership and management space, which includes cyber criminology and criminal justice, with expertise in international comparative law and a key interest in protecting creatives' rights within emerging technology, within emerging economies. His contribution extends beyond academia to influence the global understanding and enforcement of intellectual property law through collaboration and research, which aims to empower the creative industries in the global south, including Nollywood and African films. Thank you so much, Mr. or Professor Samuel Samai Andrews. Prof said he will be joining us a little bit late because he's currently in transit. So we expect him to be on call very soon. So thank you so much, sir, for the opportunity that you have granted us to be mentored by you. And last but not least, he's also his first time in this particular quarter. We are expecting to have Mr. Matt Harvey. Matt Harvey is the head of AI law and partners at Growling WLG UK LLP, advising on AI across all sectors. He is a co-editor of the Law of Artificial Intelligence. He is a trusted intellectual property advisor, especially for clients with complex patent disputes, including SEP litigation. Legal 500 has described him as standout and absolutely superb for patent disputes. His cases have involved video compression, telecommunication, 2D, 3D, LET, DSL, and other standards, aircraft design, software, algorithm training, consumer, shares trading platform, 3D modeling, consumer electronics, location sensing and traffic analysis. He has extensive experience in healthcare and life science work, including monoclonal antibodies, biosimilar toxins, medical devices, and cosmetics. He has handled product clearance and disputes involving copyrights, trademarks, design, and confidential design for clients in the aerospace, retail, fashion, automotive, and financial service sector. He successfully defended in the Kennedy Trust for rheumatology research in the UK first biosimilar disputes and helped win Fuji Films Kowa Kegrin Biology Co. Limited, the first UK Arrow declaration. Thank you so much, Mr. Matt Harvey. We also expect him to join us shortly. But for now, we'll be going straight to the session and what we have for today. And seeing that we have one of our mentors already on session, we'll just be giving the floor firstly to Mr. Gabriel to just help us run through what we have for today, his subject matter, as we expect the other mentors to join in shortly. Mr. Gabriel, over to you. We would just like to hear from you in the next 20 minutes, your take on the subject matter for today, IP. And like I said, our topic for today is IP protection for Chatgpt or AI rather.
Okay, thank you so much. I hope you can hear me. I sent you some messages, Dennis. I don't know whether you saw it, because I also have another meeting going on at this same time, a project meeting that we're working on. So I'm switching between meetings, and I don't really, I'm not sure whether I'll be able to really concentrate here, at least for the next 30 minutes, 1 hour, then I could join. Secondly, I've always mentioned, I heard you say that Prof, this is Prof's first time here. I'm not sure that's true. Prof was
For
here. I know
for
we.
this quarter,
Sorry?
I think this is his first time for this quarter.
Ah, okay. Well, I didn't know that, but because I know the last quarter Prof was here, and
Yes.
even Matt Harvey was also here last quarter. Yeah, last quarter, the last time, because we've had to present a couple of times together. And Prof is the expert in the field. I would definitely prefer to allow Prof to do,
Prof is here, but you can go on.
Prof, welcome, Prof. It's good to see you. The moment I saw the topic for today, I said, no, these guys have to get Prof here. So I would prefer, first, for the reasons that I've given, that I have to jump in on another meeting, so I may not have up to 20 minutes to do as much as. And secondly, since Prof is also here, I'd be glad if Prof could, just have the floor. I would join a little later, maybe take some questions if there's any that's directed to me. So thank you so much, and thank you so much, Prof. Please, sincere apologies for my having to swing out and swing back in, as it's quite important. Thank you.
All right. Thank you so much, Mr. Gabriel,
all right,
for pointing that out. We really do appreciate. So
okay.
We'll be handing over to Professor Samuel. Thank you so much, sir, for joining. We're happy to have you in class.
Okay. Well, I don't know. I forgot to tell you. You have my PowerPoint. I forgot to inform you that you should have brought the PowerPoint. See, if you know where I am right now, I really love this crew. That's why I just landed in somewhere which is I can't disclose, and I'm actually outside now. I have to do this. So this is what we have to do to encourage everybody to go into the track of IP and the knowledge of AI, especially from motherland. I love Africa, I love Nigeria, and I want all those coming around to take this thing seriously. Try, let's specialize. So I'm going to give, if you can go into your archive and pull up my PowerPoint on this subject. Nothing has really changed from the last talk I had on this issue, but I will send this to you. I want you to monitor. There is a colleague of ours who is monitoring the lawsuits against AI. There are 30 as of today. Maybe in the next minute it will change. There are 30 cases now. I want everyone who is interested to follow those cases, because, see, AI, we are beginning to know more. I'm talking of even the structural technical part of AI. We are beginning to know more about it now. And also the intersection of intellectual property, especially copyright and patent. We are beginning to have an overview of where we might land now. So I will send you the current list. So follow the cases, because those cases are going to become the jurisprudence. And those cases are going to be what all of us from Nigeria will be able to turn it into a policy advice, probably to change the current laws, or update, not change, amend the laws. Now, first thing you should know is that we are lucky that the Copyright Act of 2022 can recognize AI. But the foundation of whatever anybody tells you, don't forget this. As we are talking today, and probably maybe in the next, I hope our colleague is here from UK, he would talk more about this. AI is not a owner or an author of any creation as of today. That means that the intellectual property law, the philosophical underpinning, the policy underpinning of intellectual property law was to reward human beings, persons. And all the laws, Ethiopia, Nigeria now, United States, UK, actually mention persons, and they describe what persons means. So if you go back to the monkey photograph case, I hope all of you now should know the case, where a monkey was alleged to have taken pictures, and the owners of the monkey, PETA, wanted the monkey to have tutorial and ownership rights of or copyright of the photograph, and all the court said no. Even though by whatever mechanism the monkey took the pictures, the law is very clear. So don't let anybody confuse you on the internet. The law as it stands today, AI systems, whether it is generative Gen AI, whether it's predictive, whether assistive, whatever systems of AI, whether it's Chatgpt is just like what we call LLM, large, it's part of the AI system. It's a name. It's not. It's a brand. It's a name that the owners gave it. So the system itself, whatever machine learning tools that is creating a creative act or a creative work or an innovative work, does not, as we are now, does not have the protections of the law. And the popular case is the Teller case, the case that has gone to a lot of courts in Australia, America, UK. And so let's get that right. But now, the catch is, we have to project the future, because the issue is not settled, whether the law or whether the policy. It's not settled. So what are you going to do? What if? Because there's a high probability, because it's all about money. You know me by now. I always tell you, intellectual property is it's the principal derivative force of intellectual property is money, is profit, is reward for humans. Yeah, there are social components, social goods, elements of it, utilitarian purpose of it, but the old philosophical underpinning for AI. Why did we have to give people monopoly for a certain period, 70 years plus 70, so that they can benefit from their creation? It's because we wanted to reward them and incentivize them. Okay, we know that there's so many philosophical, now some people say we want it to be free and all that, but that's a discussion for another day, although I don't belong to that group. So the Nigerian copyright law as it is, the act as it is, has granted in a very powerful way computer programs, meaning software and programs, as a literary work. And if you remember your Copyright 101, works are divided into now, say, about 4 categories: literary works, artistic work, performances, or neighboring rights category. So you see now that we did a good job in crafting. It might not be perfect, the Copyright Act, but at least if you develop a software, a computer software, and if you develop a computer software or a program that is an AI learning machine or AI tool, what you should be concerned is how to protect the ownership of your program. And the Nigerian copyright law, as it is now, can do that for you. But of course, you have to understand that this area of the law is still at the beginning stage. I have not read any court. I follow it very well. I've not read any superior courts yet, any black letter law in Nigeria concerning the issues of computer software, copyright issues, ownership. What's the name of this company again? Microsoft and Anarchy. There's a case, Microsoft, they got to the Court of Appeal, but the Court of Appeal was just dealing with the procedural issues. It didn't go into that. Probably if they had done, they would have given us the precedent to back this, what I'm saying. But we have high court level, federal high court level, that recognizes computer software and computer programs as literary works. Now, AI has gone into all sectors. AI is in charge of our music, movie. Now, Nigeria is big in animation. I hope you understand what animation is. And for early scholars, please, there are very few, there are none right now. I want you to go delve and write something on it. be the first in the front so that we can recognize you in the world. If you need assistance, you can collaborate with me. Animation is getting big now in Nigerian entertainment industry, and all those are works of AI, you know. So now we should not be too concerned about giving AI copyright, ownership, authorship. I think we should be more concerned about developing AI in Nigeria, the industry. We should join the industry. If you read wide about this AI, Open AI, Google, Microsoft, Elon Musk, they are investing in owning the system. So that is what Nigerians should be concentrating on right now. The fact that people are focusing too much on should AI have copyright ownership, I understand that. I don't want to delve into that. I think it's a philosophical and ideological issue, which I still believe is good. It's not going to benefit the global South, because we don't have enough infrastructures to catch up with the money that is needed to compete with these first comers. So we should also be looking for ways how to come together, set up a company, just like we did in Nollywood. So, and this section, because I'm outside now, this section that talks about technical protection measures, all that section, you should read very well. You can use that section and develop a business model. We are very, very indigenous. We are very, very cool. We are smart. Nigerians are the smartest when it comes to anywhere you are. So we should be looking at advising people, advising creators, advising Nollywood, advising the music industry. If they want to use AI to do anything they want to do, you can own everything about the AI. We can set up a company. You can own the system, not wanting AI as a machine to own the creation from the AI, because this issue might not be resolved in this century. Because there's so many at stake. There's a lot of politics, international politics, ideological politics involved in that. But it's good to know. It's good to follow it up, what is going on now, because these cases that are trickling up in America and in Europe might definitely give us an understanding of what AI is. So I came basically to give you a policy speech. Please go back to the archive and distribute my PowerPoints on this issue so that anybody, if you have a question, even after here, my emails are there. You get back to me. And I thank you. You see, I'm sweating. It's very hot now. And I thank you for the opportunity to learn. Even as I'm talking to you now, I'm learning more. And I'm listening to all of you. I appreciate all of you. Thank you.
All right. Thank you so much, Prof, for that wonderful start or introduction to the topic for today. So we'll be moving on. And so far, we are yet to have our other mentors joining. And we've gotten a few of them notice from a few of them that they'll be joining in later on. And since Mr. Gabriel is in between calls, right, I think we'll be taking presentations from the mentees, right? After we take presentations, then I think we'll go back to Mr. Gabriel. And then after that, as our mentors join in, then we'll give them the floor to also give us a highlight into today's topic. So we'll be starting back we'll be going to the mentees for now, right? So group one, if you're ready, please, we would like to take presentation from group one, and then we'll move over to group two. For Prof's material, his PPT, we'll be looking for that, and once we find it, we'll send it to the general group. So thank you very much. Group mentees, please, if the group presenters are on call, please, we would like to take presentations now. Group one, if you're ready, the floor is yours for your presentation.
Good morning, sir.
Yes, good morning. Oyin Ladung. Oyiladun, sorry if I didn't pronounce your name very well. Yes, please.
I want to share my.
All right, please go ahead and do that. And please, while she's doing that, please, can we also have group 2 get ready for their presentation? Sorry, we can't really hear you. Are you with us?
Yes, I'm still here. Can you see my screen? I'm trying to share.
No, I'm not. No, I can't rather.
Okay, so I'm trying to do.
Please, you can go ahead and start the presentation. Let me look for your slides. You are representing group 1, right?
Yes, I'm just on the phone.
All right, so please go ahead. I will be putting up your slides now, so you can just take cues from the slides that I'm sharing.
Thank you, sir.
All right, your slides are up. Please, you can go ahead with the presentation.
Okay, sir. Thank you, sir. Good morning, everybody. I hope you can hear me. My name
Yes,
is
good morning.
and I'll be representing. Thank you, sir. So the topic that was given to us is regarding intellectual property in the age of AI and protecting creations generated by AI with a focus on ChatGPT. So this topic essentially tries to explore the advancements of AI and the impact of generative AI in the space of IT. That is, can you go to the next? So basically, the exploring this content, so the creating the topic, we try to understand AI generating content. We try to, sorry, sir. We would speak on the challenges of AI in IT, the legal framework for IT protection, just a few of them, and the ownership of AI generated work. So conclude. So please next. Okay, introduction. So it is evident that AI has been momentum and is being utilized in different sectors of the world. It's being utilized in healthcare, in different sectors basically. And with this advancement in AI, generative AI has also come about. Generative AI is the aspect of AI technology that has emerged in the advancement in AI, in terms of AI. So focusing on ChatGPT in as a generative AI tool. So please next. So what is generative AI? Generative AI is also refers to the category of artificial intelligence technology and models that are designed to generate new and original content in various forms. So AI-generated content refers to digital material created by AI algorithms, human intervention. Basically, generative AI refers to the kind of AI model that is designed to generate new content and original content in various forms. And as I wrote here that generative AI can generate content ranging from text, music, video, audio. Under text, we have different generative AI tools. We have OpenAI Chatgpt 4, which can produce coherent and contextually relevant text based on prompts provided by users. So I know that most of us we have this SII feature on our WhatsApp. Basically, if you want to generate anything from SII, basically just go there, type something, prompt it to bring up a content, and it will bring up that content for us. So that's what Gen AI, that's the example of generative AI. When you prompt it, it will bring about new original content in response to what you are prompting it to do, whether text, whether audio, whether music. So it all depends on the tool or the model of generative AI that we are using. So please, next slide. Okay, remember we said we're focusing on ChatGPT as the prime example of generative AI. ChatGPT is a language model created by OpenAI that can generate replies in open language in response to a variety of queries and questions. So I use ChatGPT sometimes if I want to like get an idea on something, and basically it would go to the website online and it will prompt it. So basically, it's like I said before, it generates replies in open language in response to a variety of queries and questions. It asks the question and it generates the response in return. So according to ChatGPT itself, when ChatGPT was asked what it was, this is what you said, like RBT, it said ChatGPT is an AI language model developed by OpenAI, which use natural language processing NLP to generate human-like text in response to various inputs. It is essentially an auto-generating chatbot that extracts data from various sources, processes it, and produces grammatically correct and contextually appropriate responses. ChatGPT can be used for a variety of applications, including customer service, chatbots, and virtual assistants. It has been trained on a massive data amount of text data, and it's constantly learning and improving. So basically, ChatGPT, like I said before, produces and generates original human-like text in response to various inputs. So you can say, ChatGPT, please give me, define what English is, and it would give you text in return. So it's text-based as opposed to some other forms that have to be audio or video or image-based. So ChatGPT produces its original content based on the data set that has been inputted before, that is consumed before. Maybe the creators, while creating ChatGPT, input some kind of data. Let's say, for example, relation to, let's say, like I said, English. The creator would have inputted the definition of English as data into ChatGPT. Then when prompted to give an answer, when someone asks ChatGPT, what is English? It would look for the data that was inputted before to generate the answer in response to the question that was asked. Help you understand. Okay, the next slide. So we have impacts of generative AI in IT. Now, generative AI, like I said before, let me just reiterate, like I said before, produces original content. So this has raised immense concerns in the world of IT, concerns ranging from rights of ownership of artificial generated content to the processing of this content. Just different concerns in the aspect of IT. Some of the impacts that you have made include copyright infringement. So one of the primary concerns in the potential of copyright infringement. AI models like ChatGPT are trained on large data sets that may include copyrighted material. If the AI generates content that closely resembles, sorry, sir, please can you go back? That closely resembles or replicates the material, it could lead to copyright violations. So basically, like I said before, ChatGPT and other Gen AI, generative AI, are trained on large data sets. So there could be a possibility where data that was inputted was like someone else's work, and that person, of course, won't be credited, won't be given credit for his work. So there could be the potential risk of copyright infringement of the person's work that was inputted as data into ChatGPT, as you understand. Now we have authorship and ownership Sorry. Determining authorship and ownership of AI generated content is complicated and complex. Traditional IP laws are based on human authorship, making it unclear who holds the right to content created by AI, developer, the user, or neither. So it is quite tasking. It is very complicated in deciding deciding who is the original author, or who is the owner of AI generated content, whether it's the user of the AI, whether it's the AI itself, or whether it's the creator and developer of the AI, the generative AI. I guess I will be going into this particular issue deeply later on. But for now, that is basically what it's about. Then we have fair use and derivative works. The use of copyrighted material in training AI models raises questions about fair use and the creation of derivative works. Legal principles needed to be evaluated to address whether the use of such material for training purposes is permissible. That is the next slide. So when legal frameworks for IP protection, I know most of us might have like knowledge on this. We have copyright, we have patents, we have trademarks, and the likes. The copyright is the IP rights or law that protects expression of ideas, that protects works of authorship, songs, books, and the likes. So in Nigeria, works that are protected under copyright include literary works, sounds, and songs, etc. So under the Copyright Act, ownership of copyright is enjoyed by the author of the work. As such, copyright law does not recognize AI-generated works. It only protects original creations of human beings. So there's a risk, there's a problem in this. Now, copyright law protects only content, original content that is that was formed by humans, by persons, and AI, as you know, is not a natural person recognized by law. So there's a very high chance that it is very high chance that AI generated works will not be copyrighted or protected by copyright law. We have patents and AI. The patent law generally protects works of inventors, as in the area of copyright. The issue of whether AI generated inventions can also be patented also exists. Now, like I heard before, AI patent law protects inventions and new novel inventions. So there are issues also in this as we had in copyright. The issue of whether AI generated inventions can also be patented. So the legal issue that surrounds the application of patent law on AI generated inventions includes issues pertaining to the ownership. So there's a very high chance that AI generated inventions will not be patented, not protected under the patent law. This is an issue of ownership. So in some cases, there is the question whether the rightful owner of the invention that was generated by AI would be accorded to the AI itself, whether it is accorded to the creator of the AI that invented that invention. There's also the issue of the user of the AI who brought about the invention would be accorded ownership. So there are different and diverse issues, very complex issues. Another issue pertaining to the possibility of AI generated invention exists in cases where it's recognized that an AI system is the sole inventor of resulting invention. So, but most countries do not recognize AI generated inventions as they don't recognize it to be protected by patent. Therefore, they are not protected since they only recognize human inventions and to accord it the protection of patent. Let's use the next slide. So ownership of AI generated works. So we are going into this issue intensely for a bit. Now, this is in regards to the question of ownership of content generated by AI, whether copyright is owned by the generative AI or the user. So this question is basically this: who owns AI generated works? Who owns the works of authorship? What that Chatgpt generates? Is it the user of the AI? Who uses Chatgpt might be the owner of the works that it generates, or whether it's the AI itself. So ChatGPT, when prompted to provide answers to this query, provided the following response. As an AI language model, I do not own the copyright of the text generated with my help. The ownership of the text belongs to the user who inputs the prompt and generates output. That one is like ChatGPT, when prompted, said it doesn't own the copyright to the text it generates. Rather, it is the person, it is the user who inputs the prompt and generates the output that owns the copyright. But it doesn't really have legal basis. Like, it's not substantial enough, as it doesn't have the answer that was provided by ChatGPT doesn't have legal basis, not substantial. So um as an AI language model, the text generated is not protected by general copyright law, as copyright law recognizes only human creators and original as the copyright owner. So that answer is quite this area is quite uncertain, and the effect is that if is that the text generated by AI is not protected by copyright law. Like I said before, it's only works generated by humans that are accorded protection, and not some works generated by AI. So, however, in some instances, the text generated by AI may be considered original enough to be protected by copyright if it was created with sufficient input, human input or intervention. Now, ownership should be accorded to the human in the instance where there was sufficient human intervention in the narration of the works. Let's say, for example, I want to write a poem, and I just prompt AI to give me an idea. Okay, and AI gives me this. It is anything trends now. Okay, the reigning trends now is, let's say, petrol prices have gone up, and AI gives me that idea. I was like, oh, okay, this is a very good idea, and I write a poem based on my own intellect and my own skills, based on the idea AI has given me. So maybe that you could say that has sufficient human intervention in that instance, and copyright law could recognize that I am the owner of that work since it was my skill, was my intellect applied, and AI just gave me the idea. So therefore, that work could be protected by copyright since AI is being solely generated. For instance, where AI solely generated a particular that work, it would not be copyrighted under the law. So AI's ability to hold copyrights stems from its legal identity or status as a non-human entity. This just reiterates what I've been trying to say, that AI generated works cannot be protected under copyright since it's not a legal entity. Either is it a human? Is next slide. Okay, next slide. Okay, proposed frameworks. Okay. Next slide. I want this was a mistake. Try on to next slide. This was a mistake.
Hello, please, can you also try to kindly round up the presentation? Thank you.
Yes, sir. Okay, this is the concluding aspect. So one of the ways to ensure the protection of AI generated work is, this was not in the slide, it was a mistake, was one of the ways of ensuring protection under IP law is sufficient human intervention and compliance with AI governance policies. So those two ways are advisable ways of ensuring that AI generated works can be protected by IP laws. So in conclusion, the utilization of AI in the production of IP assets raises complex questions, like I said. And we recommend that in order to ensure the protection of AI generated works, human intervention is required. As highlighted, most copyright laws only protect works by humans. So AI systems like Chatgpt should merely assist in the creation of processes, in providing only ideas but really the sole generator of the entire content. So that is our presentation. Okay.
All right. All right. Thank you very much, Olaindumi. Sorry if I didn't get your name again. For your presentation. Well done to you and your group for putting together that presentation. Not to waste any time, please we'll be moving on to our next presenter. I saw Mr. Ridwan joined us while you were presenting. Thank you so much, Mr. Ridwan, for joining in. So please, can we have group 2 present, and then we'll go back to our mentors so that they can also they can give us their talk and then feedback on the presentation that has been made. So please to
Hello, Dennis. Can you hear me?
yes, sir. I can hear you, sir.
Sorry, I wanted to take a leave if I can just present my few thoughts now because I might be leaving in the next less than 10-15 minutes. So just to add some things, just to share
All
some
right,
thoughts.
that's fine. That's fine, sir. We'll be taking group 2's presentation after you are done, sir.
Okay, thank you very much. So if I may, if I may continue now. I think I missed a lot not joining the class from the beginning. I believe Professor Samuel has presented already. I mean, I was really looking forward to that session, but then hopefully I think it's recorded, and I hopefully will go back to that to learn a lot from this session. So I just wanted to add a few things, and I think I can see Mr. Over on the participants list as well. Hi, Mr. Over. So quickly, I think I only have I think 2 or 3 points to mention that I think I was only opportune to look at this particular group's presentation. So I'm not sure what we have in the other group's presentation. So one of the things that I found missing is case laws, which are quite important presently to build the legal framework relating to IP and AI development or AI systems, the use of intellectual property in building the foundational models or LLMs, large language models, or whichever type of models we're looking at, or even AI systems generally. So, I believe it's just, we have lots of lawsuits presently. We have some that has actually been decided, and we have some that are still ongoing. I mean, everybody will know about the lawsuits between should that be OpenAI and I think what was the name of the newspaper again, the big newspaper company, New York. I'm not sure, but you can look that up. Those are the kind of cases I think will develop the space, and will also kind of develop how laws are going to be designed as well, how laws are going to be passed, how intellectual property are going to be maybe updated or modified, so to say. So we really need to look at, and looking at different jurisdictions, looking at different clients we have, especially when you look at the US and China, and I think EU as well, you find a bit of different approaches to interpreting the use of AI. There's a lot of issues which I really like how you kind of stated them out in terms of fair use, authorship, and I think authorship, and if AI systems or AI models can be trained on intellectual property. So I think those kind of capture the issues that we're currently having with in the space. And as I said, if we look at different cases, we see different decisions from courts. So I think when you're looking at the legal landscape in Nigeria, I think you comfortably say that it's going to probably AI generated contents are not going to be classified as are not going to, maybe they won't have any copyright protection because they're not generated by human, they're not human generated. So that might actually, we can't really see yet until we have a maybe case law regarding that. Because the reason I said that, and because another thing that is also important with this is when it comes to you advising your clients as regards what they need to do in terms of when they're using Gen AI, because everybody, almost all organizations, even if the organization has not really they've not approved the use of Gen AI. We know that almost all employees are actually using Gen AI now, and it's something that companies really need to be looking at if they don't want issues with IP issues later on. And I think that those are one of the issues, one of the developing issues that we should also kind of look into. So I was talking about the Nigerian position. I know it was as a result of your interpretation of the law. That's why it said it might not. Because if you look at, I think there was a particular law in China where there were actually two laws, where where there was an AI generated content, and it was regarded as it was regarded as also there was a decision that it's not going to be protected. It's not a copyright. It does not have copyrights protection. While there was another AI generated content which got AI by the same court, I think, which the law decided that it has AI copyright protection, and that is as a result of the human efforts that was put into generating the outputs. So these are one of the things that we should also think that our own courts might also look into, and because decisions all around the jurisdictions could actually could be one of the factors that judges or courts will look into when they're deciding indigenous cases as well. So I think that's one of the things that we really need to look into, and then how it's going to affect companies as well. So I think we just need to kind of expand how it affects companies generally. And then I think another issue we might need to look at is in terms of the terms as well. So when you're looking at, there's a lot of, we have companies using AI systems, AI tools now, and there are different implications in terms of the use of the AI system, or in terms of liabilities, indemnification, and those kind of things. And even when individuals are also using AI systems, like including Chatgpt or Gemini or what have you, are we Claude AI and the likes, Perplexity? Are we really looking at the terms of these AI tools? Are we is because some of these tools might say that the AI generated contents you're having is actually belongs to them. I think these were issues that we looked at initially, but then presently I don't think there's a lot of focus on that aspect anymore. So what I'm trying to say here is that we really need to look at the implications of those terms. We need to look at, because of course when we're comparing AI systems with other technologies or other software development software tools, there are a lot of similarities, but then when it comes to AI, there are some dynamic issues that we might need to look at separately. So that's the reason we need to also look at procurements and the issues of terms and conditions of these AI tools, and how it affects individuals and how it also affects companies generally. And so to make that clear, what I mean by that is in terms of liability, where you have, we're talking about intellectual property rights. So where you've infringed, maybe as a result of you generating content from an AI system, from maybe ChatGPT or whatever, and then as a result you've infringed on, because we've already talked about the possibility of generating intellectual property from the use of these tools. And if a company or an individual, infringes on another person's copyright as a result of generating a copyright or whatever intellectual property, so who is going to be liable for that infringement? Is it going to be the individual that generated it, or is it going to be the AI system provider? So you might actually, that has a lot of things to do with the terms and conditions. If the terms and conditions have, most of them, I think, or provide for these kind of, issues. So those are the kind of things that I think we also really need to look at if we're looking at the legal framework, or we're looking at the theoretical aspects. We should also look at how things will play out in the space or in the ecosystem. So, and the last thing I would like to quickly talk about, and I think I'll round up with that, is when you're talking about AI, or when you're talking about issues of IP in AI systems, we need to also kind of, I think I've seen instances where people are mixing or conflicting IP and the use of IP and personal data in AI systems in building AI models. And these are actually different. We have issues relating to the use of companies using personal data to build their AI models, and companies using intellectual property to build their AI models. So these are two different issues. These are two different issues. I think I'm not sure. I know we've discussed. I'm not sure if we've discussed a lot about personal data, violation of privacy, in when building AI models with personal data. But I think it's something that we really need to kind of look at and kind of distinguish and see the differences, because they have different implications actually. And I mean, because of time, I won't be able to go into that, but I think it's just something that we need to we need to kind of think about and put at the back of our mind. And I'm not sure. I want to confirm if this is our last class or if we have subsequent classes. Dennis. Hello,
So,
Dennis. Can you hear me?
yes, I can hear you.
Is this our
Yes, I
last
can
class?
hear you. So
Or
this is officially the last class for
okay.
AI, and in subsequent classes we'll be having combined classes.
Okay, interesting. Okay, I think that will be all from my end. I don't know if anybody has any question that you want me to answer before I think I'll be taking my leave now. If
All
there's no
right, thank
question.
you so much. Thank you so
Okay,
much, Mr. Ridwan.
thank you
So
too.
please,
Okay,
I would like to advise the mentees, you can follow Mr. Ridwan, and then if you have particular questions as regards some of the things he said in relation to the topic for today, you can kindly reach out to me for his email so that you can send him an email, or you can also follow him on social media so that you can also reach out to him. So I can also see Mr. Matt Harvey has joined in for the call. Thank you so much, sir, for joining in. But before we get to the rest of our mentors, we've already started with Group 1's presentation. I would just like to kindly wrap up with Group 2's presentation so that our mentors will speak to it and also give their presentation. That is for those who haven't. So Group 2, if you're ready with your presentation, you can go ahead and start. Please, who is the presenter for Group 2?
Good day, everyone. I'm Benedict, the presenter for Group 2. Don't you
Okay,
can hear
thank
what
you,
I'm
Mr.
saying.
Yes, sir. Yes, Mr. Benedict. Please go ahead and share your slides and also start your presentation. Please, you have 7 minutes for your presentation so that we can move on with the class. Thank you.
Okay, let me just share my slide. Please, if you can help me share the slide, I'm having some issues in my own end, please.
All right, go ahead and start your presentation. I'm trying to open your slides now.
Okay. Okay, good everyone. Our topic for this week presentation group 2 says safeguarding intellectual properties in the age of AI. And what we are going to say, this is the table of content. We're going to talk about the AIP protection strategy for IP protection strategies for AI creation. Two is ethical consideration. Three is talking about the international perspectives and challenges. And the last one talking about the future outlook. Please, next slide. Okay, when talking about this IP protection strategy for AI creation, talking about the how to protect this our AI created content. So the first one says the copyright registration. We are to register the AI created content in a right copyright office so that we should be able to establish the ownership of the AI created content to avoid someone or another company or industry copying your AI created content. The second one is talking about licensing agreement. Every profession, if you don't have license, you don't have to practice the profession. So using this our license agreement, the owner of the AI creator will have to have the right to his content creating, have the right to modify it, have the right to create any other one. The next one is talk about the trade secret protection, which is talking about safeguarding the the algorithm and the data model using generating the AI work. Because if you do not safeguard this data mode or the algorithm, other ones unauthorized access, there are some people will have access to it and it you can use to modify, and another one will have access to your model. So using these AI protection strategies, our AI generated content will be safeguarded. Please, another slide. Okay, so the next one talk about the role of technology in dictating and preventing unauthorized use of AI generated content. What you're talking about here is how we're going to do the technology, how technology will help us to detect and prevent unauthorized people from using this our AI generated work. Now, we're talking about the first, we're talking about digital watermarking. You see in every document, in our music, in our pictures, there is something like a name written on top of the document. This will show that this is the right owner of the work. That is what you call talking about using using in using watermark in our AI generated content to help to know the real owner and identify the real owner of the work, so that someone else or another company will not be able to do what to have right to the document. The next one said AI driven content monitoring, that you make use of using a machine to scan and dictate that this AI generated content is from unauthorized production, is not from the main owner of the production. Next one says the blockchain for owner tracking. That means use of a technology to check and to then prove the record of a generated content. Next one talking about automated takedown tools. When a AI generated content is being generated, this machine or this tool will help to know and show you that this content you want to make use of is from unauthorized person, or is this person is making use of authorized is from the origin of the work. The next one is talking about this one talking about copyright detection software. This will show that this work is from the real owner, that no other person have copied this work, like is from the initial concept of the owner. So please, another slide. So we're talking about the intellectual implications. We're talking about the problem that will result if these intellectual property protections are not clearly observed. The first one said the exploitation of AI generated content. This will lead to when this um, IP protection are not fully enforced, are not fully followed, it will lead to misuse of information, and even the owner of the AI generated content will not be credited, not be have be compensated for the redeveloper. Like the main person that developed this work will not have a compensation. The next one says fair attribute and credit for AI developers. As I said, they will not be the re owner, the re AI creator don't cannot be recognized. So with this intellectual property protection, the real owner of the AI creator we recognize and acknowledge the AI work being done. The next one says prevent misuse. When these AIP protection are not used, there will be misuse of the content created, as I said before. So when using this AIP protection, it will help that the misuse of information cannot be plagiarism, misinformation, where you don't understand what you're going to do. The next one says promoting responsible AI development. So you are talking about the company had to detect
Mr. Benedict, can you hear us? It
plagiarism
seems you're not.
and ensure that please I can't.
All right, please go ahead. We were not hearing you for a bit.
Oh, sorry. Please, next slide. Okay. Next one is talking about the international perspective and challenges. So talking about this international perspective, talking about what have been happening around the world. This variation in intellectual property laws and enforcement mechanism, you have that there is a judicial differences. That means in every part of across the countries, the laws are different. If you come to this particular country, a different particular country, so there cannot be there will be international challenge on this AI content. Next one says the legal definition of AI regulations. That means about the law. When the laws are different from each or all the countries, it's it will be very difficult to do what to have the AIP protection. The enforcement challenges when the laws are different from every country, that is very difficult to do or to enforce the laws of the AIP. We have the AIP specific policies, like we talk about that some countries have already moved far ahead in developing this AIP, while some countries are lacking behind. So when these two countries, there'll be difference and be challenging when the two countries are making policy on how to make use of this IP protection laws. So the next one says the global effort and initiative for harmonizing IP regulations. We are talking about the effort globally we have been making for this to enforce this intellectual property regulation. The one is talking about the World Intellectual Property Organization. This group is doing their best, is working hard to see that there will be standardized AIP laws across the nation for this AI created content. The next one say international cooperation, that countries are now working together to see that the AIP laws are being formed, are being organized, so that all the nations will have the law at their guide. Next one says the harmonizing of AIP laws, that the global initiative focus on aligning different legal frameworks. So all of them are already coming together to gather and how to know and how to outline these AIP laws so that all countries, all nations will be moving forward towards it. Next slide, please. So the future outlook, we're talking about this future outlook. What are we expecting in the future for these AIP laws? Next one, the first one says that the redefine authorities. We're talking about these redefine authorities, that with these AIP laws, we need to know, we know the real owner of the AI generated content. Next one says AI specific regulations, that the experts in the law should come together, should help to align the intellectual property laws being used. The next one says global standardization. The next one says global standardization, that the whole there will be a greater pursue towards international harmonizing of AIP laws for AI, that internationally that everyone should come together so that you can standardize the AIP laws. We have automated IP enforcement, that they should have tools that can dictate the rights of this artificial intelligence content creator, so that they can enforce the laws, so everyone will have to, so that everyone will have to be part of it. Please, next slide. Recommendation for policymakers, industry stakeholders, and AIP developers. We are talking about the recommendation that the policymakers should one is said about the policymaker should develop a flexible AIP law so that the laws can help in the advanced AIP content, because we are moving from one step to another. So when they should develop a policy that can help in that, not only in the present one we're talking about, and even in the advanced, so that everyone will have to cooperate. We're talking about the industry stakeholders should encourage the legal expert. They should incorporate the local experts in their laws and even the license making, so that every law and every intellectual property laws will be followed up. Next one, still talking about the AI developer should build in a mechanism that should dictate a plagiarism when a content has been copied, or when a content are not flowing from the right, from a content is being used by unauthorized person or unauthorized party. The next one says the global corporation force that they should have a partnership to streamline the IP protections in all over the world. Talking about education and enlightenment, where that everyone, both the legal expert, the technicians, and even the AI generated content creators have been enlightened about the laws, about these AIP laws. Like, please, sir. In conclusion, what we are talking all the things we said about these AIP laws, that it that the AI advanced challenge existing, that the law already exists in some parts of the country, that the advanced one is already time, because it does not have a standard guide for the advanced AI created content. This judiciary variation, that in the laws, the the enforcement in every part of the nation are not the same. And the next one said that the global efforts aim to humanize their applications, for like the groups are helping together using the one I talk about, the World Intellectual Property Organization. They're working globally to safeguard and form and even guide some countries that are not into this AIP laws, for them to have a grant. I'm talking about the future AIP framework, that the future AIP framework will help to know the ownership of any AI generated content. Talking about the key recommendation, that you're talking about the policymakers, you're talking about the industrial stakeholders, AIP developer, calling all of them to they should adapt to these AIP laws, help in creating a license model, so that all these AIP protection laws will help in every upcoming or any already generated AI created content. Thank you. That's the end of my presentation.
Mr. Ikechukwu, are you done?
Yes, that's the end of the presentation, sir.
All right. So thank you so much for that presentation. Well done to you and to your group for putting that presentation together and also presenting in class. So now we'll be moving back to our mentors. At the start of the class, we had a few mentors who were on call and were able to deliver their presentation, and others joined us subsequently as the class was going on. So we also want to hear from those mentors that just joined in, right, so that they can give us their presentation and also a little feedback to the presentations that were made by the mentees. So I'll be going with Mr. Matt Harvey. After Mr. Matt Harvey is done with his presentation and his feedback, we'll be going back to Mr. Gabriel and then subsequently to Professor Samuel. So thank you, Mr. Matt Harvey, for joining.
Well, thank you very much for having me. And I'm sorry I couldn't find the details of the meeting to join earlier. Let me start by giving feedback to Benedict on what we just heard. I thought that was an excellent presentation, and thank you. And I totally agree about your survey of the diversity of approaches in different countries to the issue of whether AI output should be protected. The UK, where I'm from, is one of a handful of jurisdictions which have specific laws for copyright protection for works about human authors. We have provisions for what's called a computer-generated work, and it may be a kind of copyright. People are a little unsure about how it works, and there've only been 2 cases really that have considered it so far in a number of years. But the idea is broadly that where you have the output of a computer, not necessarily AI, without a human author, it is protected for a shorter period of time. I think it's 50 years. And the person who owns it, you need some sort of rule for that. And it's the person who made the arrangements for it to be created. And that might lead to some debate as well. But that's just a default rule. And the terms of, let's say, an AI company such as Midjourney could say who would own it by default. And generally speaking, I would say the industry norm at the moment is that all such companies tend to say that if there is any copyright in outputs, it belongs to the user. Some of them, though, do ask for a license back of that copyright. So that's something to watch. Looking at the sort of big picture of your presentation, there's a real debate actually worldwide about whether AI outputs should be protected by copyright at all. And I think breaking that down into a few topics, the first is assuming our aim is to promote the use of AI, is copyright needed in the outputs to do that? The evidence so far is that literally more than 100 million people are using some of these platforms, and they are generating outputs, and they aren't concerned whether there is copyright in the outputs, and they can usefully use those outputs for various purposes without any copyright. So if a company is using images for its research purposes or to generate ideas, to test out potential marketing ideas, if they're using it internally, they're not really worried about copyright protection, the outputs. If they are putting images into social media, knowing that they only want them to last a few weeks, again, they aren't worried about copyright. And indeed, in many cases, companies want to create text or images to promote their products, and they want people to copy it. They want people to share it. They want it to go viral. So again, copyright isn't always crucial for every use of an AI output. And there seems to be a strong business case that isn't reliant on IP protection. So I think the broader question, why there's a lot of debate around the world, is whether copyright protection for AI outputs would benefit society as a whole. And one of those issues is economic. So would it generate growth in a country if AI outputs were protected by IP? And here I think governments are worried about how to balance the interests of essentially innovation, tech companies, and that sort of part of society with what you might call the creative industry, filmmakers, writers, artists. And there's a concern that if you change the rules on copyright, one side or the other may benefit, but it may create a problem to the other side. And how do you strike that balance? So that's the economics of it. And I don't think anyone has any clear answers. And the other is it beneficial to society to encourage AI to create when previously it would only be humans creating in this way? And should copyright be given to AI outputs if it would encourage that trend? And there are concerns for some people about human dignity and preserving human creativity. And if we encourage AI outputs which are creative and might replace or just drown out the work of human authors, is that something governments should pursue. So all I'm saying there, I'm not taking a side, I'm just saying there's a huge debate on whether to extend copyright in this way at all. And then you talked about harmonization internationally. And I think on this topic, we are unlikely to see harmonization, certainly anytime soon. And that is because, as you said, the laws are currently very varied. Because, as I've just said, no one knows what to do, and people in countries and people can have very different views. And I also think it is not it's not a critical issue at this point. And I think there are more important challenges when it comes to harmonizing laws around AI, which are going to come first. And the other thing I would say is that harmonization of IP laws historically can take decades. So I suspect the business model for AI outputs will be very well established by the time anyone is reaching a harmonized position. And I suspect the harmonized position at that point will be irrelevant because business will have just done and society will have found its own solutions in the meantime. So very briefly, the things which I think will be ahead of IP protection in terms of the international agenda. One is everything to do with AI safety and the broad issues about society. So issues like deep fakes, I think, are going to be much more significant and get there before IP ownership. And then I think within IP, I think what is considered, I think, broadly to be the more pressing concern is the use of human output to train AI, and whether the exceptions to copyright to allow the training of AI are appropriate around the world, and whether that should be harmonized, and whether there are licensing solutions such as creating platforms to aggregate data and allow people to license it easily in a legal way, whether that can be encouraged to solve that problem. So that's my feedback. Fantastic talk, and there's a sort of summary of where I think the diversity of views are on the issue. You mentioned a presentation. Am I supposed to give a presentation? Is there anything in particular you'd like me to talk about as well as giving feedback?
Sorry, thank you, Mr. Matt. Based off of the presentation, we meant just generally your talk on the topic itself. So if you have anything to add as to, besides the presentation from the mentees, based off of what you prepared ahead of this class, what you would like to discuss with us.
Okay, well, I'm here. I can answer questions, but anyway, so far, fantastic. Thank you very much.
All right, thank you so much, Mr. Matt. We'll be having a session for questions a little bit later on, but we would like to go over to the rest of our mentors down call to just get a little feedback from them on the presentation, and then we'll go to questions and answers. So, Mr. Gabriel, are you back with us, sir? Okay, I can see. Okay, Mr. Gabriel is no longer with us. Professor Samuel. Prof, are you with us, sir?
I'm here.
Yes, sir. So, sir, we just want to get a little feedback with you based off of the presentation and maybe any other thing that you would like to add in regards to this class.
I'll just do a 5 minutes because Matt. Welcome, Matt. Nice to see you. I've been following you. Thank you for all you are doing for the AI Academy, Matt. Matt has already done a lot of what I wanted to talk about, because I noticed in the presentation this issue, which if you had listened to my opening speech, I already laid that foundation. I came as a form of conclusion, which, although it's still debatable, we have to be careful, like Matt said. the issues of what we are going to do concerning the copyrightability or the ownership or authorship of outputs generated by AI, as currently as it is, in quotes, is settled. Because why am I saying that? Because the law as it is that copyright, creative works, artistic works can only be owned in terms of their copyright value by humans, persons. Laws in most of the majority of the country of the world, especially the in quote, what is the countries that really matter, meaning the countries that their economy drives, the realities of the world we are in, including Nigeria. It's for humans, it's for persons. Now, I think the Federal Court of Appeal, United States Court of Appeal of the Federal Circuit has given us where I think most of the coming rulings are going to land. I told you, everybody should check. There is I'm going to find it and send it to you to pass along. There is a scholar who is monitoring as of today. There are 30 cases so far. Maybe it will be 31 by tomorrow on this issue of the active lawsuits, meaning it's not abstract now. People are actually arguing the legal basis of it, not the technological basis of it. So before my battery runs out, and so when you are talking about this issue, you should realize where we are, whether it is a generated output or is an input that is gotten from a machine learning tool. The machine itself does not own the copyright. Now, like the memorandum, when the Court of Appeal in the US ordered the parties to file a memorandum and the ruling of the court, I think it's going to be based on how much of a machine was involved in creating those outputs, whether it's artistic, music, film, or whether it's literary, books, or computer programs. So AI, as it is, does not own any copyright, even patents. I think so, based on where we are. Except laws are changed in countries, but even if you change the law in your country, how are you going to make it enforceable in the committees of nations? So that's the problem Matt was referring to. The issue of standardization, I don't want to drive, Matt has already said it, it's going to be very difficult for you. I think I talked about this issue my last class here 2 weeks ago. Standardizing creativity rules or norms is going to be very difficult in the world we live right now. So I'll leave it there. Great presentation, and I might not be on for too long because, like I said, I'm outside, I'm on transit, so I might be off because my battery is going down. Thank you.
Thank you very much, sir. We really do appreciate that feedback from your end. So we'll be going straight into the question and answers segment. So I'll be posting some of the questions that was sent in by the mentees to the general chat. So please, I also like to encourage all the mentees to also ask questions. As regards the class for today. So we have the questions already on the chat box, and seeing that this is just the last segment to class, we'll just be having Mr. Matt and then also Professor Samuel help us run through the questions. So sorry, the questions are a little bit duplicated here. So the first question here is, what are the ethical implications and recommendations to safeguard intellectual property in the age of AI? I'll go over the question again. The question is, what are the ethical implications and recommendations to safeguard intellectual property in the age of AI? I think we'll be handing over firstly to Mr. Matt. Sir, if you can help us with that question, we'll really appreciate.
Yeah, of course. So the question's about ethical implications, not legal ones necessarily. So as Professor Samuel just said, there are around 30 cases in the States which are dealing with the issue of whether training on AI is an infringement. Whether training on copyright works is an infringement in those works, whether outputs of AI might be infringements of human-generated works. So we don't really have any court that's answered any of those questions yet, but we are seeing developments of what people consider to be ethical solutions. So we're seeing some providers, Adobe and Shutterstock, for example, who are training AI on their own library of images and things which are now the public domain, in the hope that that creates a more ethical solution because it hasn't used content where the court hasn't yet decided if that was allowed or not. I think another interesting area is whether you should use an AI to replicate the style of a particular person, even if that isn't copyright infringement. And generally speaking, at least in the UK, the courts have said that style isn't protected by copyright. And some countries, particularly across the European Union and the UK, have specific exceptions for what's called pastiche, which is, I think, although there's uncertainty about what it means, it appears to mean a work in the style of someone else. But even if that's not illegal, there are concerns that it might be unethical. And I have certainly spoken to artists who use AI and they won't put the name of another artist into their prompt because they consider that to be unethical. And we are also seeing some AI providers create filters or other technical measures to prevent you asking the AI to output works in the style of particular artists. So that's the sort of headline that I'm talking about ethics, not the law. And the other thing I'm seeing is AI use policies are quite common now at companies where generative AI might be used. And they warn people typically not to mention the rights of third parties in prompts. And they may tell people to potentially do something like a Google image search on an output to check if it's like someone else's work, to try to spot infringements before those outputs are then used publicly. I think, what else can I say? Safeguard property in the age of AI. I think other recommendations, not ethical, but recommendations to protect IP. Obviously, in the States and some other countries, you can register your work, and that gives you more protection to bring a claim. In other countries like the UK, it's not necessary to register. There are sites such as Spawned, I think it's called, where you can attempt to register your work as opted out so that people aren't supposed to then train their AI using it, but that's a very uncertain area of the law at the moment. And finally, there are some technical products which claim to be able to protect your IP. There's one called Glaze, I think, and one called Nightshade, I think, which can create an invisible watermark, essentially, or an invisible layer of your artistic work, which apparently doesn't agree well with the AI model that's trained on it, and quote unquote poisons the AI model and would discourage the use of your work in training. Do you want me to move on to another question, or shall we see it?
All right, thank you very much, sir. So we'll just be taking a question from Professor Samuel so that we can just quickly hear from him before he logs out. Thank you for helping us with that question. The second question here, and I'll be directing it to Professor Samuel, is how can patent law address AI-generated inventions?
Well, we are still, I just echo back, just put the answer of maths. It's still the same. We are still in the same conundrum. Patent deals with innovation, the technical issues and inventions. So the ethic to me is a running around legal traps, because it's ethics, so it's not law. So you try to, the AI industry probably using the law in place, which is fair use or fair dealing, like they claim, the courts will tell us whether it's correct. We should be careful, not to use, for example, let's look at the health sector, the kinds of medicines and the kinds of drugs we're going to do. What are the kinds of testing, whether it was ethical for you to use without consent, without legal basis, experimenting on people's body and those kind of stuff. So it's still the same, just like they say, circle back to what Matt said, and that's all I can give for now. Thank you. And I think I'll leave it there. I'm like 1% now. Thank you very much.
All right. Thank you so much, Prof. Thank you also for joining us in today's session. We really sincerely do appreciate your presence. Mr. Mats, do you have anything to add in regards to that?
Well, not to that question, and I'm sorry we're losing, or have now, I think, lost Professor Samuel. So shall I just move on to the other questions quickly and give you my views on those?
Yes, that'll be fine, sir.
Yeah, so the next question is, how can patent laws address AI-generated inventions? The current status of the law has been tested in many countries in relation to inventions made by an AI called Davis. And everywhere where the court has got involved so far, or at least on appeal, they've made it clear that a human has to be the inventor for there to be a patent granted. So that's the current status of the law. We're not really expecting a different outcome to be seen in other cases or on appeal. So I think we're fairly sure that's what the law is going to be. Now, that leaves the question of how much a human has to do to still be the inventor where they've used an AI, and the court is going to have to start looking at that on a case-by-case basis. So the question is, should patent law be changed? And I think patent law is a very significant example where, without international harmonization, there's very little point in an individual country changing their position. And that is especially the case for inventions, because in order to get a patent, you have to reveal your invention to the world. And in some countries, such as the United States, you also need to tell people the best way to do it. So if they're only getting protection in a single country or a handful of countries in exchange for making their invention public, I think they're unlikely to pursue that form of protection. So I don't expect any change in anyone's laws to protect AI-generated inventions in the near future at all. Next question, how can international IP agreements address AI-generated content? I think we've ended up talking about that quite a lot. Professor Samuel and I have both talked about the fact that it's going to be very, very difficult to get international consensus on that. And so I think institutions like WIPO are talking to individual countries and giving them lots and lots of support and materials on what to think about. And they will be, I'm sure, exploring whether some sort of harmonization is possible. But I suspect it will be country by country making changes. I don't think we're going to see a lot of international harmonization. There are exceptions. If the EU became interested, that would be a block of countries that might end up with a harmonized law. But certainly I don't detect much pressure or enthusiasm within Europe for AI outputs to be protected in this way. And then the next question from Praise is, what are the implications of the EU AI Act on intellectual property rights? And that is a very hot topic, and there are some really, really quite profound impacts of the AI Act on IP. And essentially, during the writing of the Act, generative AI became a very important topic, and they added a whole lot of provisions into the Act, which are now in force, or rather the Act is in force, and the obligations will in fact begin to come into force from August next year when it comes to IP. The key provisions are all about enabling rights holders, so people who own copyright, so humans who've generated copyright and publishers who have copyright and the like, to enforce their rights in respect of the training of AI. The key provisions are, first of all, that AI companies have to respect IP. They have to check if people have reserved their rights, if they've expressed an opt-out saying that AI shouldn't be generated, shouldn't be trained using their works. AI developers, when it comes to general purpose AI, which would include most generative AI, have to publish a summary of the content they use to train their AI. And it's clear that that's to enable rights holders to know if their work had been used. And finally, and very controversially, they have said that if you train outside of the EU in a way that wouldn't be compatible with EU copyright law, you can't then bring your model to the EU. And potentially that might even include you can't bring the outputs of your AI into the EU. So yeah, thanks for that question. Really important topic. A lot has happened there.
All right. Thank you so much, Mr. Matt. So that's all the questions on the chat box. Do we have any other live questions from the mentees? Do we have any other live questions? Okay. In the absence of any live questions, I think it's safe for us to call it an end to class. We've had quite an interactive session from the ends of our mentors and also from the mentees based off of the presentations they made. So thank you to everyone for being a part of class. But just before we go, we would like to just kindly quickly take pictures, and then we would just wrap up and then call it a day. So please, I would like to ask our mentees. Thank you, Praise. I can see you have your video turned on. Please turn on your video if that's possible, so that we can take a quick screenshot for our social media posting. All right, please, can we have more mentees turn on their videos? Thank you very much. Please, you can also smile. Thank you. All right. Thank you to everyone for cooperating. Thank you, Mr. Matt, for your time. Thank you so much for also giving answers to our questions. We sincerely do appreciate you've been with us quarter after quarter, helping us guiding us in the space of intellectual property as it regards to AI and Chatgpt. We sincerely do appreciate your presence and your time. We look forward to also seeing you in subsequent quarters, and you also sharing your knowledge and insight with us. From us here at GIIPC, we say a very big thank you. I would like to ask all our mentees, share what you've learned in class, tag our mentors. You can also reach out to them on LinkedIn. You can connect with them, ask them questions, and I'm sure they will do well to respond to your questions and also give kind admittance to you. With this, we've come to the end of today's class. Do all have a lovely day ahead, and goodbye.